Hi, thank you for coming back. Just one panel between you and lunch and Pablo and his siesta. This will be a short fire 1 hour, hopefully. We're looking at 10 years of enforcement, what the last 10 brought us and what the next 10 have in store. I will be swift in introductions. You know all these people. If you don't, look them up on Bing or invite them for a drink or dinner. They're house trained. Nicolas, Kim, Kai-Uwe, Vanessa, and Lars. We'll start with Lars, because Lars was on the European Commission team which drafted 2003 back in the day, so he'll give us a historic perspective of what we've got behind us and what's to come, and also if you're responsible for any of the situations we're in nowadays.
Well, I probably am, but I don't want to admit it. So what I wanted to do is just offer a quick perspective on, you could say, the policy reforms that happened. We're cheating a bit more than 10 years ago, because it's very clear from the interventions today that we're now getting into a new phase of policy reforms. This time around, it's because the world around us is changing at a perceived rapid speed, and all that change makes people inside and outside the antitrust community question pretty much everything we do. And they're asking the question, should we now rewrite the policy that we have been applying for the past 15 years or so? And if we decide to do that, what should those new policies look like? And as a way of introducing that discussion, I think it was useful to go back to the policy debate that we had 10, 15 years ago and just briefly revisit what actually drove those reforms. And the first fundamental platform for the debate back then was, what should antitrust really be about, right? Why do we have antitrust rules? Why do we have enforcers? What are we trying to achieve? And when I now hear suggestions about climate change and the like that should form part of competition law enforcement, it's very much reminds me of the debate that we had 10, 15 years ago, where the question was also, should we promote environmental objectives? Should we promote employment objectives and the like? And the decision that was taken at the time was that in order to give antitrust legitimacy and its special purpose, we had to focus on the core of antitrust, which was, and that's enshrined in one of the recitals to Regulation 1, it's to protect competition on the market for the benefit of consumers. That was the objective of antitrust. And then the second driver of policy reform was very much inward-looking. The Commission was basically asking itself, are we doing the right cases? And what policy should we have to make sure that we do the right cases? And that ended up being the buzzword of a more economic approach or a more effects-based approach. But the essence of that was really, you need to make sure that you look at all the relevant facts when you decide which cases to do and when you develop them. And as you analyze your facts, you need to have a sound theory of harm to guide you in building your cases. And that meant that at the time there was an effort to have sort of less emphasis on by object and more emphasis on by effect, because we thought at the time that would make the Commission do better cases. So back in 2003, when the court came out in Michelin 2, we were all very depressed because it went in the opposite direction of actually looking more at the facts and the effects. And then let's fast forward to today. Personally, I actually think that these principles that we looked at back then make sense still today. I completely recognize that there is a need to have another look at policy because the economy around us is changing. When we did the past policy review, it was against the backdrop of an economy that hadn't changed much in the earlier decades. Now there is a lot of change, and we need to make sure that our rules are up to date. But I still think that we need to have a robust reason for having antitrust, and I think that still remains making sure that, that markets work well and for the benefit of consumers. And I also think that it's even more important today to focus on the facts and understanding the markets that we're dealing with, exactly because they're changing. So if you make shortcuts on the facts through factual analysis, through presumptions or by object and so on, I think we'll be back in where we were 50 years ago, questioning whether we're getting to the right results. And there are a couple of recent cases where I think illustrate the risks that we're losing policy rigor. One is the German Facebook case, which personally I think has nothing to do with antitrust. It's not about protecting competition on the market. It's consumer protection, but other people should deal with that. And the second one is the Google shopping case, where there may very well be an antitrust problem, but I don't think that there is a rigorous theory of harm and to back it up. I mean, this idea that, oh, there's leveraging and you're now favoring your own services on your own platform, okay, that can be part of the analysis, but for me that's not good enough to now come out with sort of far-reaching principles. So my hope would be that while in the past couple of years we've had much of the hipster antitrust, Lina Khan approach to antitrust, which is let's raise lots of problems and issues, that we now say, well, let's seriously think about how we turn that into robust principles for applying antitrust in the next decade. Thank you.
So just quickly in 30 seconds, Google case, the theory is not good enough. What about all the companies that left the market? What about the increasing dominance over search in that time? Is that not, it might not be an antitrust problem, but is that not good enough?
Well, I mean, my personal view is that the real issue in the Google case, and I'll disclose that I worked with Microsoft when they filed their complaint on search, that in my view the real issue was actually search and trying to get more competition into search. What the Commission focused on was all these verticals that essentially is market regulation, because you've basically given up on trying to address Google's dominance in search. And I think the difficulty of coming up with good remedies tells me that something's gone wrong somewhere. That if you have a clear-cut, you could say, theory and facts to support it, then typically you come to a solution that is actually workable and implementable. And if you end up, after X number of years of investigation, with a remedy that is incredibly hard to make workable, I'd question whether this was the right case to do in the first place.
Okay, thanks very much. Just move, Lars and the Commissioner were talking about the new context of industrialization and digitization. So perhaps you'd like to develop that a bit for us, Vanessa.
Sure. So going at slightly more macro level, if we look back at the last 10 years, my view is that in terms of industrial policy and politics more generally, they have played a limited role in competition enforcement, perhaps for the reasons that Lars just mentioned. Obviously, there have been attempts to try and increase political influence over cases, but they haven't necessarily come to huge amounts of fruition. But the question I have that I would raise is, are we now in a new territory after Siemens Alstom and the aftermath of that? And if so, what impact might that have? So we know that there are a number of member states, 3 member states in particular, who are pushing for more kind of industrial policy in competition policy. And we've probably all read the conclusions of the March Council, European Council, stating that the EU will continue to update our European competition framework to new technological and global market developments. And we also know that the Commission President, in her mission letter to Commissioner Vestager, has made a link between industrial and competition policy. On the other hand, we also know there are a number of member states who are against industrial policy in competition cases. So where are we going with this? The debate's not actually new. If you look back over time, there are a number of member states blocked proposals by the European Commission in actually 1973 and 1981 to bring in a merger regulation, because that regulation was based purely on competition principles and not industrial policy. So you could argue that competition policy to date has largely been based on competition and single market principles. But Are we now in a different place? Does it still hold true today for where we're going in the future? I'm wondering whether the current economic trends at the international level are actually different in the sense that we're no longer driven by liberalization, but quite often in certain places by economic nationalism rather than free trade, and whether that context is different for the current industrial policy debate. There's a paper by Bruegel which identifies that this is particularly topical right now because other world powers don't separate economics from geopolitics in the same way that Europe does. So China has influence, for example, in a number of member states through economic activity in those member states. The US is willing to, for example, use financial sanctions or financial policies to support its US geopolitical goals. And to state the obvious, the strength of the US technology companies also has raised a number of major concerns on technological sovereignty, as has already been mentioned. Although that's not limited only to digital, where the US obviously has a number of strong players. So does this mean that the kind of industrial policy currents are today significantly stronger than in the past? And does that mean that EU competition law might not come out of this turbulence as completely unscathed? It's obviously a bit of a mug's game to make predictions about the future, but I think maybe we can have an attempt to do that to a certain degree, in the sense that there seems to be broader political agreement on tackling the digital economy, which may lead to more robust enforcement in that area, and perhaps less political agreement for laxer enforcement to allow the creation of European champions. But I'll have a go at seeing where that comes out. Obviously, the Commissioner, with one big exception, didn't give much away in terms of where she wants to go with this. Having a look at it in antitrust, I think we can probably safely say that the political backdrop of the technological sovereignty concern and the overall societal issues which were raised by Jorge and Philip very eloquently earlier on, those kind of backdrops won't stand in the way of stronger enforcement in the digital sector. But to my mind, it will be key to work out what antitrust can and should do and what it should not do. I suspect also in terms of the digital area that, particularly in light of the mission letter that I mentioned earlier, that Broadcom won't be the only interim case, especially in the digital markets. And if you look at the German proposals for reform of competition law, faster enforcement is also a subject there. So I suspect that may continue to be a driver at European level as well. We've touched on, in a number of the presentations earlier, the concept of consumer welfare and whether it might be broadened out. On the one hand, moving it beyond price, or further beyond price than has maybe been the focus previously, could lead to stronger enforcement in the digital markets. But outside of digital, one could potentially imagine the inclusion, and I'm sure Maritz would welcome this, of environmental and sustainability issues in that concept, leading to a more permissive, for want of a better word, type of enforcement that would allow environmental considerations to be taken on board. Looking at maybe mergers, killer acquisitions comes up all the time. I think there's a bit of debate around how one would deal with that. But other potential issues, areas where there might be change, without commenting on whether this is a good idea or not, well, I think I don't need to say anything further about the market definition notice. I think we're clear on where we're going on that one. But perhaps we might see other trends from industrial policy angles from politics and also from business, as we've seen this morning from the European Roundtable, that there might be pushes for more flexible analysis of potential competition going beyond the 2-year timeline, although that was never legally binding. Also looking at innovation, potentially also efficiency analysis, but I hope that doesn't become a backdoor to more industrial policy considerations. And then something that the Commissioner touched briefly on, the new Commission's work programme currently suggests that Commissioner Vestager will publish a policy paper entitled Instrument on Foreign Subsidies, currently timetable for next March. And that's designed to look specifically, in, as I understand it, a separate tool, at the effects of foreign state ownership and subsidies in the internal market. So quite a lot to be thought about. Perhaps also in merger remedies, I don't think this has been discussed much, but it has been pointed out that 1 in 2 sales in divestitures has gone to non-European companies. Whether that might lead to a thinking of having more behavioural rather than structural remedies in merger control might be an interesting issue. And state aid, I think the Commissioner actually hinted that we might see some development in that, not only in environment and energy, but also probably innovation and projects of European interest, given the current industrial policy pushes. My suspicion is that the Commissioner, having learned the ropes in her first mandate and knowing better what she wants to do in her second mandate, will be bolder in enforcement terms, particularly perhaps in digital, and the political winds will certainly be behind her. Obviously, we have the issue of the dual mandate, but I'm not going to go through the arguments on the issues that raises. One thought that did occur to me, and I'll leave you with this thought, is that given the Commissioner's mandate is so vast now, the question I would ask myself is, will she have enough time to oversee the cases individually in the way that she did in her past mandate? And if not, what could this mean in terms of influence of DG Competition or other advisors? And if there is any question mark over that, do we need any kind of more checks and balances in the system?
Thanks, Vanessa. Just over to Kai Uwe to develop your point on industrial policy or the change and balance between competition policy, competition enforcement and industrial policy. Kai Uwe, do you see them as in conflict, as infecting each other, or is there a way that they can inspire each other as well?
Well, I think that there's actually been a dramatic change, and it's kind of goes along. Lars has talked a bit more about kind of the evidence side of things, but I think there's also an underlying philosophical change that's been quite dramatic. I think in the pre-decade, and I think it's really important to go back to that as Lars did, we were actually quite concerned of isolated competition from industrial policy. But it was also kind of much more a decade in which we thought it was important to impose processes, get politics out of the market process, that distortions were induced by politics, and where we saw problems also in the deregulatory process. I'm thinking about, for example, electricity markets in Spain. It was partially where they weren't deregulated, and we kept, for example, price caps on end prices, where later we got a state aid case on the same question, basically because in competition sometimes prices should be going up. In mergers, we had this firm position of Germany that industrial policy should not interfere. And there, kind of, I think also the move much more in the direction of evidence through the court decisions as well, isolated that for a long time also from, and even now, if I'm thinking about Siemens Alstom, from industrial policy intervention because you always kind of have the arguments in the end. Here are the data, here's what kind of substitution actually is, and it's much harder to overturn. But I think the big change really came with the financial crisis. I think post-financial crisis, politicians were quite willing to say, well, we see that markets don't work, therefore it's legitimate to kind of go and impose outcomes, and that's what we also want to see from all policy areas, including competition policy. And so that gave much more possibilities of saying we want to intervene, and we want to intervene on things where we even don't know the theory of harm that well. And I think we're now at a point where we're even a step further if you're looking at the explicit statements of German industrial policy concepts. They're basically saying competition policy should be an instrument of industrial policy. This is a nice quote I like from this. We do not want disruption. We want gradual transformation in the interest of our industries. Okay, so there's your nationalism coming in the economic sphere. And so I think kind of partly these pushes that we're now seeing to make merger policy more lenient and at the same time intervene much more in the digital space is actually a coherent part of an industrial policy strategy, which one has to recognize when we're looking at some of the changes that people are advocating also in the legal framework. I think some of these things are rather dangerous. I mean, Frank won't like what I'm going to say. I wasn't involved in Siemens Alstom. I just saw the case coming up and went, how on earth can this possibly go through? Everything that I've heard since has kind of confirmed this in a way that we had the typical questions of kind of, what is the market here? Everything's global. We had this in Outokumpu Inoxum as well, where again the European Roundtable said, you're not taking these things into account. We actually did import competition, was an outside the market restraining force that we took into account, as the commissioner described for another case here. And one of the reasons why I'm actually worried about the push along those lines is that there are areas in merger policy where we should think twice, because we've had a lot of industries that were going down that have needed restructuring. I think the other Alstom case, GE Alstom, actually was one where there was a firm and very severe financial difficulties, and the question is, how do we deal with restructuring under those circumstances? There was a serious discussion about this when I was at the Commission. I think there is a question of whether Outokumpu Inoxum was correctly handled. It was correctly handled according to the competition instruments at the time, but we had two failing firms, essentially, that were merging, in a sense, given their financial situation. That is kind of an area that would need serious discussion, but I think it's overwhelmed now by these policy concerns that are all about China becoming big, and the question in these cases is, where are actually the efficiency effects? On the digital side, we have, because of this industrial policy perspective to this, a real push towards ex-ante intervention. And I'm seeing this again in Germany in the potential reform of the competition law and this new Article 19a, which is kind of geared towards saying in digital markets, we have platforms, there are networks, networks tend to go to tipping, therefore we're creating something for platform firms that look a lot like GAFA. We're going to have rules, including things where we say they shouldn't go into other markets in which they aren't because everybody else is going to exit. I think that's very dangerous because it also doesn't fit the facts about what we know about networks effects and to what extent they're actually leading to tipping consistently or very much not consistently, where we have a lot of developing and very competitive market. And one last point on this, I think, which is very related, is within that context, the desire to have a powerful instrument like competition policy take up other policy area issues is a really dangerous trend because most of these issues are not related to market power, and therefore the remedies are also not related to the market power issue. So Lars was mentioning the Facebook case, and I fully agree with him there. Kind of one of the issues with these privacy issues is that me as a consumer, I have no idea whether aggregating certain pieces of data is something bad for me or not, okay? Given that I don't have any idea, I'm not going to substitute along that dimension, and there's a lot of data that supports that. So if that's the case, the problem with it is not related to market power. We're never substituting. So a competition remedy that says now you can substitute isn't going to do anything. Well, that's exactly the remedy that was put in, namely give you a choice. And I think in that dimension, Jorge is absolutely right from what he said this morning. If I give you a choice and I don't know how to compare, and if on top of that there are the types of externalities that Jorge talked about, we're going to get remedies. We pat each other on the shoulder how wonderful we intervened, which the Bundeskartellamt does for itself, but also kind of some of the digital regulators, privacy regulators. And we're just going in the wrong direction where we really have to think about how do we have to intervene in an effective way, which is not a good way for competition regulators to go. So I think that's just one example in which this takes us into a direction that's neither good for competition policy nor for the other concerns that we actually have.
Thanks, thanks, Koiva. Just come on to Nicolas. One of the points that Koiva was developing there was, I suppose we would be forgiven for thinking that antitrust is digital. Digital is antitrust at the moment. It is a driving force for many of these reform questions. It's led to an explosion in the US political debate. Is that a problem, that digitization, the questions thrown up by digitization, like Lars and Koiva were saying, is the driving force for this reform?
Okay, so I'm going to do something very French. I'm not going to reply to your question. But I'll use a segue to get there. So a few years ago, I was fortunate enough 5 years ago, to do a trainee, and a typical trainee at the European Commission. And at the time, the new commissioner was just in, and I recall talking to colleagues there, and I was asking, so what's the difference? And they were, I think the one sort of common line that came was, the communication is way more direct. The communication is way more direct. And my reflecting about what we saw in the past years, I was thinking to myself that what we really saw was a more self-confident Commission policy. The policy language is much more straightforward and direct than it was ever before, and that has a lot of upsides. So we have a less technocratic Commission policy, at least the way it appears. And also, we've seen many efforts to try to reach out to the public opinion. So it's no longer sort of talking between officials and lawyers and economists, but officials go to conferences, meeting data scientists and philosophers, and they talk about a lot of the things which concern the public opinion. So I think we have reached a level where there's probably more accountability in the system, and less of the Schuman Square ivory tower problem that was so criticized before. Now, when we prepared the conference, I saw some email, we exchanged some emails, and Louis was asking, so what's the good, the bad, and the ugly about the past 10 years, right? So the good is really that, more accountability. The bad about it is that I think this has increased demands from the non-specialist press, so not you, but I would say the non-specialist press.
I'm just waiting for you to tell us who's ugly.
For sort of sensationalistic antitrust headlines, and we are seeing antitrust anecdotes become real market events. So Facebook doesn't even start Libra, sort of thinks about Libra and talks about that. And then you have some sort of demands from the regulators about, what is it about? And then it becomes a real market event, and it's a catastrophe, and we have to prevent that. It's not even in the pipeline. There's a lot of uncertainty about whether that project will fly at all. And so I think this sort of sky is falling rhetoric in the conversation is very unhelpful. There's been a recent book by Thomas Philippon, a professor of finance at I think New York University, or can't recall, called The Great Reversal, and he compares the US and the EU, and he says the US turned its back on free markets, and the EU applied competition law very seriously in the past 20 years, which means that the prices and the output that we see in Europe is much better for consumers. If this book is to be taken seriously, it means that we need to steer the course, not just sort of reinvent everything and reinvent the rules. We've done pretty good. So the ugly in all that, to me, is, I'm sorry to say that, hipster antitrust. Hipster antitrust is counterintuitive, counterproductive, and polarizing. You have to understand what it is about. It's not really interested in the truth. It's interested in a political power play to change the landscape of the political structure in the US. It talks about bigness, but not about bigness in terms of dominance. Any bigness in scale, size, labor force, and so on and so forth. Thurman Arnold in the 1930s, he said, that it's akin to discuss whether buildings are too tall. This is a bit what hipster antitrust is about. But I think the most important point about hipster antitrust is that it reminds us that antitrust is context dependent. So a lot of the institutions that we have in the United States, labor market protection, taxation, environmental protection, consumer protection, operate at levels of intensity way weaker than we have in Europe. And that quite legitimately increases the demands of disgruntled people to have antitrust do something about it. In Europe, we have a lot of legislative and regulatory equipment and infrastructure to cover legitimate social concerns. And that should lead us to think that the world of hipster antitrust is not flat. We should not, the globalization of markets doesn't mean the globalization of ideas. We should not import as such hipster antitrust. We should be very careful and understand what we have here besides antitrust. You want to ask something?
Keep going.
All right, so the sort of...
Are all hipsters ugly?
Yeah, I think that... I cut my beard before I came, not to appear as a hipster. Now, I think the relevant question is whether that's more self-confident competition policy has impact on enforcement. And I think we can really see it. I mean, there's a credible case to make that. This self-confidence can be seen in practical empirical realities. So we've seen a rise in activity in unilateral conduct cases, especially in digital. We've seen experimentation of novel substantive theories of harm in merger control. Think of Dow DuPont. We've seen procedural innovation with interim measures, and now we're talking about shifting the burden of proof for certain merger transactions. We've seen more confident recourse to secondary legislation, private enforcement, ECN+, and maybe again, burden of proof. And we are seeing to some extent an even more stricter application of national competition law with cases such as the German Facebook case, which to some extent don't have much to do with the market power, consumer welfare-driven policy that we had. Now, the funny thing is, and that's where I'm going to be a little critical, that self-confidence that competition policy displays and has displayed increasingly in past years doesn't cut down to the sort of fine print of technicalities. So Google Shopping is a case with a very unclear theory of liability. There's a lot of facts, but there's very little about the substantive theory of liability that Google is apparently subject to in this case. Status of the guidance paper. I mean, no one really knows today whether the guidance paper is a zombie document or whether it's still good law, except maybe one former member of the legal service who has spoken very explicitly about, in papers about the status of the guidance paper. We're also seeing, I think that's really key in terms of the sort of self-confidence, but not cutting to the details. We're having a lot of uncertainty to understand whether the outcomes that we've reached in certain cases can be seen as precedent by business organizations to adapt their conduct. So if you think about Google Shopping, or if you think about Google Android, the real important question for many businesses is, can we bundle? And in digital, a lot of firms bundle like crazy. And a lot of firms with, I would say dominant positions bundle like crazy. So the question is, what should these firms do when they face a precedent like Google Shopping or Google Android? Does it mean the end of bundling? Does it mean the end of vertical integration in related or adjacent product markets? This is very unclear, and I think we would expect more self-confidence from the European Commission to tell us, through guidance or rulemaking, whether this is indeed the case or not, just not the sort of easy, the particulars of the case as such that we don't do that. Last but not least, I think in terms of the sort of uncertainties that we face, endgame in digital. What is it about? Are we trying to create horizontal competition against platforms in tipped markets? Another search engine, another operating system, a more privacy-compliant social network? Or are we revenue sharing, are we doing sort of revenue sharing exercise to promote the content developments, the programming layers of the industry? And I think, when I look at it, when I look at the copyright directive, when I look at all the other instruments, the copyright directive, the e-privacy directive, the P2B regulation, when I look at all that, Google Shopping and other cases, it seems to me that we are more on the revenue sharing side of the policy landscape than on promoting horizontal competition in digital markets.
Thank you very much, Nicolas. Moving swiftly on, time is tight. It wouldn't be a competition law conference if we didn't talk about procedure, and the judge talked about procedure this morning, about some of the procedural, the flurry of appeals on RFIs and on dawn raids, which question mark whether it was restricting the ability of the regulators to do its job. So Kim, perhaps you'd lead us off on procedure.
Thanks, Lewis. So when I got this invitation, I started reading 10 years worth of Commission annual reports. And that's actually an interesting...
I'm so sorry.
No? I know, shocking. It's actually an interesting read. So it's very easy at these conferences to talk about policy, should the Commission do differently, etc. But when you look back over these sort of 10 years of developments in detail, some themes emerge that we're maybe less conscious of. So that's indeed why I wanted to talk about procedure today. And I won't just talk about court dawn raid cases, because maybe that will come later. So what are the sort of procedural themes? Why do I think that's a real focal points of the last 10 years? Well, last started mentioning Reg 1 2003, so 10 years before the 10 years we're thinking about. And that was really all about the what. What do we need to do differently in competition policy? We need to empower the national authorities, we need to empower the national courts, we need to free up the Commission to be doing those cases that it should actually spend its resources on. That was the how, right? And then we were stuck with, that was the what, and then we were stuck with, well, how do we do that? How do we enable all these other enforcers, all these other entities to kind of play their role? And how do we do it in a bit of a conform way? And so that's the what. And if we look back at the last 10 years, we actually see a lot of amazing sort of progress on the what. So what were the real challenges? Well, we have dozens of national enforcers with limiting stages of powers and experience. How do we bring them along? How do we ensure they enforce competition law consistently? And then also we've had the concept of private enforcement. I'll come back to that, which was the sort of buzzword that didn't actually happen and which in the last 10 years has started to happen. And how do we make sure that's again done in some sort of uniform way? So those were the challenges. What do I see as the key 3 innovations of the last 10 years? Firstly, on 101 substance. Secondly, on enforcement procedures. Thirdly, on private enforcement. So on 101 substance, 10 years ago, we had the block exemption regulations and we had the guidelines. And if we think about it, and whole conferences are, of course, dedicated to discussing whether those guidelines have served well and where they need to be improved, etc. And I won't repeat any of that. But if we think about it, they have done a lot to ensure uniform application of EU competition law by the national authorities and by the national courts. And really the sort of detailed guidance that they provided, especially vertical relations, horizontal relations, are the springboard based on which we're discussing some of the cases here, right? If we think of the Bundeskartellamt with its real focus on verticals, if we think of ECJ references that have come really from across the EU based on, focused on vertical issues, really all of that is based on the vertical guidelines. So an amazing, amazing piece of kind of legislative or commission guidance to the national authorities that's helped with the, how do we do this decentralized enforcement? Then procedures. We've got lots of national authorities across the EU that actually don't have the most basic tools to help with enforcement. This is where ECN Plus, Nicolas just mentioned it, has come in. They are authorities who don't have clear powers to request documents, to request evidence, to have sort of compulsive, if you like, a comprehensive answer to questions, dawn raids, etc. So right at the end of my 10-year span that I'm looking at, we see ECN Plus directive, and of course we don't know yet how it will play out, what difference that will make, in particular in Central and Eastern Europe, where a lot of research has been done around the real enforcement gaps. But it's one example of how the sort of how do we do it is being focused. The other example I will just mention there is around the hearing officer and the ombudsman. The much more central role that we now take for granted. And if we just think back in my 10-year period to the arguments over publication of the Commission's procedural manual, and the sort of controversy at the time. And again, has that not been a document that has led to transparency and consistent enforcement from a procedural perspective across Europe since its sharing, its large publication? So that's my second procedural point. And then my third point is around private enforcement, and I just want to delve in there a little bit, Lewis, and that's around this, this kind of slight ambition that we had that undertakings, companies should be able to enforce competition law directly. If there's harm to consumers or harm to customers or harm to anyone, there should be mechanisms for compensation. And that's been a desire, I would say, really since the outset of competition law, but we didn't achieve it. Some jurisdictions like my own, the UK, has been a forerunner a little bit in terms of competition litigation. We've had private enforcement cases really over the last 15 years, I would say, consistently. But of course, it's the damages directive that has brought that to all of the EU member states. So 2013, towards the beginning of my period, we had the Commission's proposal for the damages directive. Of course, there were other legislative attempts leading up to this, but the shape was clear in 2013, got published 2014, was supposed to be implemented about 3 years ago. Of course, lots of member states took longer, we know that, but it is uniformly implemented now across the Union, and it's being used. And it's not just being used in those countries that have a reputation, the UK, Netherlands, Germany, it's being used across. I'm dealing with cases in Romania right now, in Hungary. We've had a reference on an issue to the ECJ from a Hungarian court, so it's being used across the Union. The idea, of course, and it was a directive deliberately, was that it was to integrate within the national systems, if you like, common minimal standards, without kind of prescribing necessarily how they were done. So a minimum standard on access to evidence, clarity about the status of Commission decisions and national authority decisions in private damages contexts, a presumption of harm, controversial, as hopefully the next 10 years will show, but nonetheless, there it is, a presumption of harm, the consequences of passing on, and then, very importantly, limitation periods and how private damages can be brought even when investigations are very long-running, so ensuring this kind of interplay between the public enforcement and the private enforcement works. So, some of the countries have done pure copy-out implementation approach, so we don't actually see how the interplay will work out. But nonetheless, it's all there, and it is being used. Where I see real challenges, and maybe I'll finish on one example for that for now, is that there isn't this clarity of thought yet within the community and within the national regimes around the interplay of the public concepts and the private concepts. So I'll give you just my one example, the concept of undertaking. We heard, in fact, earlier Mark van der Wally talking about parent liability cases, and surely the ECJ has seen enough of those. Well, I think the concept of undertaking, we definitely aren't at the end of the route. That was probably a subtle hint, wasn't it? Some people interpret the Skanska judgment as effectively suggesting that any member of an economic unit, so any corporate entity within that economic unit, is effectively liable for the conduct of any other member within that unit. And look, I understand where that reading comes from. The language in the ruling is unfortunate. I think we have to remember that it's a successor liability case. But it's quite troubling to think that actually this broad competition law concept of undertaking might be translated into civil liability systems, which is exactly what the directive shied away from, why not a regulation is used, but a directive is used, not to mess up the civil liability systems, and yet here we find European case law that effectively suggests that these public enforcement concepts should be read into civil liability context. So more work to be done for the next 10 years, but I think a lot has been achieved in these last 10 years.
Thanks very much, Kim. Vanessa, just over to you. What's your view on the state of procedural law? Is it in a healthy place?
I think I'm going to take it in the sense of procedure in case investigations, so linked to the substance. But in there, I think over the last 10 years, we can see a number of trends. First of all, significant use of internal documents, which, and I can completely understand the logic of that, as explained by the Commission this morning, but I also sometimes see a temptation to be rather selective on the use of internal documents. Another trend, I think, over the last 10 years has been the increase in the use of economics and in a greater variety of theories of harm. Now, both these trends could or should lead to better decision-making, but clearly have an impact on the cost and length of review, as Frank Montag illustrated earlier. Now, you could say that's great for lawyers and economists, but I would actually question, as Frank did as well, whether we're not, in fact, in danger of overdoing it now on both sides, on private and on the public enforcement side. And a bit like the President of the General Court, I'd be really quite interested to do a study of how many of the critical cases that are decided today would have been decided differently 10 or 20 years ago without these massive, massive procedures. I think that would be quite an interesting study to do. I think another development that we've seen, particularly recently in the 10 years, is more procedural infringement cases in merger control, misleading information and gun jumping cases. We didn't see those quite so prolifically previously. And as Kim mentioned, actually, another development, I think, is a greater use of best practices or publishing best practices by the Commission. I mean, we lawyers all complain all the time about lack of transparency, but I think the Commission has come quite a long way in the last 10 years in improving its procedural transparency. I've been focusing now on mergers, but if I look at antitrust, what strikes me in particular is the increased use of commitments, well, at least until recently, as Alfonso pointed out earlier, but perhaps more particularly settlements, not only in cartel cases, but in non-cartel cases, the so-called antitrust cooperation procedure. Now, I think that can have pros and cons. Clearly, it has some pros for resource allocation and speed of result for both the Commission and for private parties. And for companies, it's a way to avoid or reduce fines. But I do think that we also need to keep an eye on potential downsides in terms of transparency, as you were saying earlier, legal certainty, and the potentially little or even no judicial oversight in some key policy development areas. So I think those are some trends we've seen. Where do we go from here, or where would I like to go from here? Having sounded a slightly skeptical note on levels of quantities of evidence, I nevertheless think that if we're going down greater enforcement in the digital area, it would be beneficial to enhance DG Comp's fact-finding and evidence-finding toolkit. To include, for example, given access to data scientists, AI resources, because I think accurate and pertinent evidence is going to be essential for good enforcement, not only in digital, obviously, but in all areas. But also in terms of evidence, in my view, I think greater use of, and Kayuva may disagree with this, but greater use of behavioral economics as part of economic analysis is important. So neoclassical economic theory is based on the premise that consumers and firms are rational, profit-maximizing entities. But behavioral economics, based on substantial empirical evidence, is a method of economic analysis that recognizes that human decision-making is not always rational and that people are actually boundedly rational actors. And if consumers hold biased beliefs about the values of particular products or services, they may then demand too little or too many of them, and that will distort demand, and therefore competition may not necessarily maximize efficiency. So what do I mean by these consumer biases? I mean, there's loads of them, but just to mention a couple: status quo bias, which means that people are less likely to switch products or services, which, if they don't, then can lead to decreased incentive on the part of the providers of those services to improve them, which in turn obviously leads to less rigorous competition. That might be relevant in the tying and bundling scenario in particular. Another area would be saliency bias, where people tend to focus on what is prominent to them, what they see. And if consumers are subject to saliency bias, producers may compete harder on the salient bits of competition and less hard on sort of secondary areas which are less obvious to consumers, which allows companies potentially to behave more monopolistically. So producers can design their products to take advantage of these consumer biases, but where the biases are predictably deviate from rational decisions, the efficiency benefits of competition have been shown to be less pronounced than traditional economic models might suggest. I'm obviously not advocating that abandoning traditional economic based enforcement, but I think it would be useful to think more about how to recognize and take into account systematic behavioral biases that may distort outcomes. We've seen that the use of behavioral economics in a few cases, and I commend DG Competition for that. The Microsoft browser case is a good example of that, which was the remedy was based on the implications of status quo bias, i.e. that people tend, oh, that was a bad pun, sorry, not intended, people tend to stick to pre-installed browsers. Or Google Android, which more explicitly, in fact, relied on behavioral economics, referencing, again, the status quo bias about people being likely to stick to pre-installed apps, even if they could technically switch and download other apps. I think there is also good evidence, actually, from people like Amelia Fletcher, who've looked at behavioral biases not only for people, human beings as consumers, but also in the corporate field, corporate executives taking decisions that may not necessarily be profit maximizing. For example, decisions making based on empire building or short-term stock market value. But that then leads to the question that if mergers are not driven purely by profitability motives, but some executive biases might interfere here, you might need a more subtle analysis insofar as, for example, efficiencies are concerned, or similarly, if you're relying on potential market entrants or divestiture purchasers who are overconfident for personal bias reasons, that could affect the likely success of the post-merger situation. And the CMA has actually looked at both these scenarios in retroactive studies with interesting results. So my plea would be that understanding how consumers and companies actually make decisions could be taken into account more in the assumptions of antitrust, because they're central to predicting the competitive outcomes post-transaction or post-investigation. Obviously, that should not necessarily lead to more anti-competitive findings. It could be the other way around, particularly, for example, in a tying or bundling scenario. But I think particularly in the digital sphere, it strikes me that the consumer voice, and by that I mean the boundedly rational consumer voice in many cases, needs to be heard further. I could also go on for many other things that I would wish to happen, in particular guidance, but that's already been mentioned, and I hope that we get more guidance beyond the sort of one-off cases that have been decided, but I'll leave it there.
Thanks very much. Just a final topic before we go into lunch break. I'll start with Nicolas. He promised to tell us what the best and worst judgments were of the EU courts for the last 10 years. In 4 minutes.
Yeah, in 4 minutes. Okay, so I'll focus on the Court of Justice, the upper court, in 101 and 102 cases. So I think there will be no surprise in the room. The good. In 101, Carte Bancaire and Coty are really reasonable cases, and I like that. In 102, Post Denmark 1, Intel, MEO, and FM are cases which are also helpful because they do not only speak clearly about the substance of the law, but they also embark and import a lot of economic common sense, not sophistication. The bad is this sort of process which you have with the case law of the Court of Justice, where it makes 2 steps forward, but then 1 step back. And so interspaced into the sequence of cases that I just mentioned, you have Tomra, Expedia, Post Denmark 2, TeliaSonera, and maybe Alrosa, which to me seem to be this sort of, ambivalent, schizophrenic process at the Court of Justice, where you want to move the law, but you don't want to get rid of, all the precedents. And so you have the sort of long trends which improve the clarity and the legibility of the law, but you also have these moments where the court sort of feels compelled to recite precedent, which is actually not a European tradition to apply precedents in the case law. The ugly That's very simple. This is Allianz Hungary, which is a complete nutcase. We don't understand how the courts made this sort of useless confusion between restrictions by object and by effect. It actually made the work of the plaintiffs in 101 cases and agencies in 101 cases very hard. And we saw following cases like Servier, where the Commission had to both advance on a restriction by object and by effect, which is intellectually inconsistent. The recent case law has sort of expunged its judgments from references to the Allianz Hungary judgment from it. Just one word maybe about the sort of high-level teachings that we can get from, I think, the case law. One is the court likes to answer substantive law questions with procedural answers. We can see that in Intel and Huawei. Two, in abuse of dominance cases, the court prefers to set abstract standards than structured rules or quantitative thresholds. There is a resilience of concepts like all the circumstances in the 102 case law, or references to the economic and legal context in the 101 case law. And so this is the sort of, I think, spirit of the courts, rather than have very clear structured rules which provide for detailed tests of liability in conduct cases. The court prefers to leave that a little more abstract and provide for frameworks. Real clear signals from the Court of Justice. The presumptive approach, the by objects spirit, is only exceptional. Intel and Carte Bancaire makes that very clear. This is the exceptional way to go. As a rule, second thing, as a rule, harm to competition is an empirical question. It's not a categorical question. You don't box a case into a by-object route simply because of its form. The third teaching that we have is you need to ensure consistency across 101 and across 102. The Intel 6 factors for assessment of abusive conduct are the same as in the old de limitis case law of the Court of Justice. So we are reaching a level of consistency between 101 and 102. And last but not least, efficient exclusion is lawful. We are seeing less and less and less reference in 102 cases about ideas like competition law is about increasing choice, or competition law is about making access to competitors not as difficult as it was under the abusive conduct. Open questions. Will the General Court implement these normative changes in annulment cases lodged by defendants in 101 and 102 cases? Open question number 2, dominance. Market depth and market power assessments remain the sort of lost area of the Article 101 and Article 102 case law. And this is critical in dynamic markets where tipping effects or untipping effects might be prevalent. We need to know more about that. And last but not least, consistency between 101, 102, and merger control. The court made very clear that you only use the sort of by-object reasoning in 101 and 102 cases in exceptional cases. Does that logic also apply in merger control? And if this is the case, are initiatives designed to rebalance the burden of proof in merger cases really compatible with the spirit of the case law in 101, 102, and merger cases? Recall that in the Austria asphalt judgment taken in the last decade, the Court of Justice insisted that merger control, Article 101 and Article 102, share a common set of goals. It's very clear in the judgment. So, there's no lex specialis for mergers insofar as presumptions are concerned, I think.
Thanks very much, Nicolas. Kaiva, just to turn to you. We have a sense of evidence-based enforcement built up over the years and effects-based and so forth, but then the debate seems to be moving to more presumptions and ex-ante interventions. How do you see the lie of the land?
I think what's actually remarkable at the moment that we, at the same time, have kind of a movement in the courts, which is always a slow movement because of precedent, but in the direction of more effects-based and evidence-based enforcement. And at the same time, we're moving very dramatically in the opposite direction. I think partly just from the competition authorities themselves, partly from the legislation that is being proposed. And I think partly the competition authorities have also tried to preempt, just by preempting legislative intervention, by actually going more towards a presumption approach. And so I think it's worthwhile to kind of stress that how important for merger policy the lost cases were around the change of the century. Probably GE Honeywell even more, although it was upheld, kind of the substance of it was completely put aside. And the reason in all of these cases was just an incredibly sloppy way of dealing with evidence. I mean, I remember in GE Honeywell writing a report on the court on this, and I always remember this example that kind of one sentence says, so GE is incredibly financially powerful because it has a AAA rating. Thales just is not very highly capitalized. Well, they had a AAA rating as well, right? And it was consistently, every point in these decisions was like this. Now, I think that's led to a dramatic change in the way that mergers actually have been handled. That's also led to economics having actually been welcomed on these cases more and more as actually a tool to actually back up what you're saying. And and it's actually strengthened the defense against desires to overturn decisions from a political point of view. Because once these mergers get into the political process and someone criticizes, he said, well, here are the facts. And then it was very, very hard to say anything against that once it got to the political level. So I think in mergers we had this. In antitrust, not so much, because the court was so much slower in that area, right? I do think the guidance paper in 102 had real impact for a while. For example, we had a situation where we would never accept to say there was price discrimination because you charged a different price to yourself, to your own subsidiary than to someone else. That had to be a margin squeeze. And that was, I mean, some case teams were chafing under that, but it was still very much pushed through. I think one of the striking things for me in the Google search case is something that you have mentioned. That second leg is gone, right? It's now favoring yourself, and you're not looking at the foreclosure aspect anymore, which it was the margin squeeze aspect. And that's just really, really worrying. It's an undermining of a theory of harm and what actually needs to be proved in order to have a consistent case. And I think that's what we're kind of going in the direction of, the desire to go back to situations that is consistent now with a political push in making decisions with less information. That's the point with reversal of proof. We don't have to have the burden of proving anything anymore. We want to reverse, and, well, you come, and it's very easy to say, I don't believe it. You get this in a lot of jurisdictions anyway. The same thing with the ex-ante intervention of Article 19A in the proposal for the new German competition law, which is also all about defining firms where you expect problems and then say, we don't have to test anything, whether there are specific problems here, there's certain behaviors you can't do anymore. The same thing with interim measures. I remember we had a discussion back when I was at the Commission about interim measures, and there was a reluctance to go there because it was saying, well, you know, one of the reasons why we have a problem in this case is that we're really not quite sure whether there's a problem or not. So how can we impose interim measures which are already requiring information that we don't even have? And that was the reluctance of actually using these measures. I can't judge the case in which it now was used, but again, the desire is to kind of shut down the degree to which we're actually asking for the information before we're actually making a decision. I'm very aware that the argument against this is these things are taking too long, right? How long are they taken at the Commission? How long are they taken then at the courts? Are we actually getting the deterrence effects that we actually want if this takes forever? Now, one of the things, though, I think that's very often overlooked in this debate is a lot of the cases that take a very long time are cases that took so long because there were serious, serious doubts whether there was a problem. I remember kind of a foreclosure bundling case that I took over because my predecessor had already worked on it for years and was skeptical. It had the typical thing that it went through one revision after another. There was even a statement of objections, an oral hearing that didn't go too well. In the end, there was a commitment decision after 8 years. and the complainant hadn't exited the market yet. Right? So there you kind of ask yourself, and you see this in a number of cases. A lot of things that take a very long time go through iterations of trying to adapt the theory of harm. The evidence doesn't fit. And so in a lot of these cases, people are just not very happy with the fact that it's so difficult to prove something that's actually coherent as an argument. And I think that's actually dangerous to actually retreat from that and say we want to go back to something that is simpler for us, especially in a world that's so complicated that we actually need to understand it in order to know whether our interventions actually make sense or actually have really negative effects because they're holding up innovation and the dynamic process in these markets. And so I find this really dangerous in terms of the potential negatives that we even don't know how to evaluate in the first place.
Thanks. Lars, I'll give you a chance to respond to the interim measures point and presumptions.
Yeah, as you mentioned, Kayuba, there was a long period of time when no interim measure decisions were actually adopted. And then all of a sudden now in 2019, we have one which we're involved in. And it's clear that a driving force behind that is, you could say, a sense of, you could say, urgency and the need to act in order to solve problems before it's too late. And there is also this perception that as soon as a market involves some kind of technology, it's prone to tipping, and therefore you need to act quickly in order to prevent that from happening. And again, I think it's useful to go back to, as you did, to the reasons, why was the Commission in the past so reluctant to do interim measures? And we can go back to the previous one, which was the IMS case. And say the problem with the IMS case was that it raised quite a lot of novel, complex issues, and therefore wasn't suitable for interim measures in the sense that there wasn't a clear-cut set of or theory of harm, set of facts where you could basically quickly establish that there was a need for intervention. And then once you have that set of facts, the conditions for imposing interim measures, which is urgency, prima facie infringement, risk of serious and irreparable damage to competition, when those facts come together, then of course you can act swiftly, and you can also expect the companies to respond swiftly to statement of objections and so on, because everything is clear-cut. The problem is that those are not the cases that the Commission does. The Commission does the complex cases that you could say it does because it thinks that it can have a real impact on markets. But as you said, Kai-Uwe, in order to understand what kind of case you have, what the remedy might look like, it requires a massive investment in simply understanding the facts. Now, once you've made that massive investment in understanding the facts, you've taken so long that you may as well move to adopting the final decision. And I think that was a real reason why, after IMS, the comp said, well, let's not waste time on interim measures, let's just try and move to the final decision. And I would say, let's try to find ways in which to shorten the decision-making process, because when you look at what the Commission does, very often you spend as much time, you could say, discussing the issues and how to proceed that you actually spend on investigating the case. And if you could cut some of that time spent on trying to agree on the outcome, I think you could actually move much faster in these cases, and you wouldn't need to rely on interim measures.
Thanks very much. It's lunchtime. Well done for getting through without coffee in the morning, without a pee break mid-morning. I'd like you to thank the panel in the usual way, and we'll see you after lunch.